Good morning, friends. Today we are going to talk about the Law and Economics Lecture 5. This lecture is largely on the economic theory of property rights. I keep telling about the importance of economic theory of property right and economic theory of property right in the previous lectures, and this lecture is in continuation of what we have done earlier. And this today, what is specifically I'm going to talk is actually the economic property right theory, as we have already discussed about. That is, there are two different versions of property right we have come across. The legal right theory or legal property right theory, and the second one is the economic property right theory. So today I'm going to talk about the economic property right theory. Two major discussions on property right of resources largely centered around this discussion. First one is this common property, and the second one is private property. So all the literature on the economic theory of property is basically on this aspect, that is common property theory as well as the private property. So what is a common property, or what we call the commons? So this is a very important question because many people had talked about this thing. Right from our earlier lecture, we get to know about this thing, that common property right, especially when Garrett Hardin said that there is a possibility of a tragedy of commons is there. So in that context, what is a commons is also very important, and how it is defined, and what are the characteristics, and how this is actually leading to tragedy, etc. is the concern of economists who were discussed, and that part we have already seen. Now, in that backdrop, common property versus open access is very important to be defined. That is, in the Samuelson's understanding of an open access or a pure public good, things are defined completely different vis-a-vis what we are going to discuss. Two key factors in that analysis is very important. That is, common property is something to do with a tenure, that is the group right. The second one is actually the management or the institution, how it has been managed. Can a pie of land be both common property and an individual property is a question normally people try to ask in this backdrop. So in the slide, it is a very crumpled points which has been there, but logically it is connected. That is, first of all, there are different varieties of property. In that, common property, private property, states property, then open access, etc. are there as the parcels of land or right. Okay, so within that context, we are going to talk about the common property. So once we are into this realm of common property, then, as I said, what is common property and how it's being defined. Okay, so once the common property is defined, then we can say that what it is not an open access or a private property. So in that, again, I would like to make a point that common property, we mean that there is a tenure as well as there is a management. The tenure is largely done by a group of rights, and management is a function of the institution and its play. Then the question which I mooted earlier, that is raises its own relevance. That is, can a piece of land be both common property and an individual property? Is it clear? Now let us talk about the open access case. Open access is actually open to anyone to use. So that kind of use is a use which is will increase until no user can make a profit. So the degree of scarcity is critical issue as far as the open access things are concerned. once the commodity is non-exhaustible and non-depletable, then normally there is no problem of open access. For example, though there is a cost involved in the production of a commodity in the internet space, but once it is being produced, then it can be replicated. So in that context, what is actually the possibility of using that resource is unlimited. In that case, it is actually terms as a open access resource. This may not be very strictly correct, but for the time being, for this lecture, this can be useful. As the same thing is even applicable to the commodity, largely the thing which we inhale and exhale, which is our air, okay, the oxygen or the carbon dioxide which we exhale. So this is actually, we can say that an open access where you can, but you can't do that. It's in a very different space. For example, space, you can't have this. So it is also a spatial restricted one. So in that context, it's very important that is open access is open to anyone to use. Use will be increased until no user can make a profit, and the degree of scarcity is a critical issue. So this is a degradation will occur if level of use exceeds sustainable level. So this is the benchmark with that of the open access case. Then we also have the problem with the common pooled resources, which is largely called the commons. What is a common? Open to defined group. So common property doesn't mean that it is actually common to everyone. It is a commodity which is open to a defined group. For example, if I'm an Indian, means I am entitled to a thing which comes under the purview of the Indian state. If I'm a Malayali, I am actually entitled to use things within this purview. If I'm a university professor, say I'm a professor in the Department of Economics, then I am entitled to use the resources which is available in the Department of Economics, University of Kerala. So this is what is called a commodity which is being specifically defined in terms of its own defined group as well as the boundary, which we had discussed in the early lecture. So the problems arises as scarcity increases. So normally the issue of the common pooled resources arises when the resources is not an unlimited resource. That means if it is a scarce resources, then the issue of depletion or overuse, etc., will emerge. So do users have means for effective control in that context? Again, we have another set of issue which is called the public property, which is normally state holds right, and is it effective in managing or excluding by state, etc., are the questions which is normally mooted or confronted in our daily life. Similarly, there are other set of cases which is called open access case, which I have no effective management is possible. This is what is people try to say, but there are difference of opinion in that context too. Again, we have open access resources, which is largely creates the discussion on the tragedy, which is trying to emulate the tragedy is inimitable when use exceeds the sustainable level. We know all this, we have already discussed all this matter in the earlier lectures, but I'll come to these issues in a step-by-step manner. Common pool resources where tragedy less likely, but control mechanism must be effective. Now, as a solution to the open access resources, normally every community try to put out a solution. That solution is what is called the common pool resource solution. that common pool resources are those resources which is in fact less likely to create the kind of tragedy which Hardin was advancing in, or Hardin advanced in his proposition or in his paper. So we will come to that issue a little later. But the underlying fact of this particular proposition is that common pool resources reduces this tragedy through the mechanism of an effective governance, or what we call effective governance may be one of the mechanism which is governs the common pool resources, which leaves to the other set of resources which is called the private resources. A private resources is those resources which is having a single owner, where natural or corporate persons are the owner of these resources. We all know, for example, if I have a mobile phone, I may be a private owner of it, or if I have a parcel of land, then I may be a private owner of that. So all this kind of things can be put under this framework, though we will be discussing all the nitty-gritties of this in the subsequent lectures. So complete control is actually what a private property right envisages. That is, a private property is in Samuelson's definition, a private good or property means you have a complete excludable right. You can exclude others from use, as well as there is a rivalry in that. So very pretty obvious understanding of what is a private. Owner assumed to maximum long-term value of property, therefore they may be actually going for a private property. So this is the logic which is normally applied in the commodity kind of privatization. So capital asset value release or what you call the resale value, which also part of this particular concept, which says protect, or which or try to emphasize the fact that the protection against the misuse is being ensured through this particular concept, and optimizes rate of utilization of resources. These two things are being ensured under the capital asset value. And the second one is income flow, that is make best economic use of property. So if you are a private owner, naturally you can best use of this thing. So as a question of this understanding, there are many other propositions which we will be discussing in a subsequent lecture. So a combination is normally being expected when it comes to the different attributes of the resources which is available to all of us. So if it is common sense that all of us can look around and see that what kind of property we daily come across. That means we are traveling in a public transport bus, which is partly the state owned and partly you pay and use a fee, so it is partly common part. So there are so many mix of property which we encounter in the real world and our daily life. So there is a combination of the right which is normally being discussed. Now, what is the basis of discussing an economic theory of such a resources? The basic theoretical understanding or the concept which normally we try to understand the sort of resources is from the perspective of a transaction, or we call a governance issue. That means Coase had introduced a concept which is called the transaction cost premise, which is actually a cost which is occurs when maintaining possession, or to say governing the commodity or possession we have, which comes with both a physical maintenance such as flowing, occupy the things, maintaining boundary lines, etc. As well as the legal one, transfer of right, whether we can actually effectively transfer what we have with us to somebody else. So these are actually largely called the transaction cost, or we see that the governance cost. I'll come to this portion also in the subsequent lectures. We can discuss that a bit elaborate. Now the question is that who is going to own this particular cost? Who is going to incur this cost? Whether this is going to incur or borne by the society, or whether it is borne by owner or third party. So this is a very, very important question as far as the transaction costs bearing. So as a primitive society, or society was said to be transitioned from common to private property. So this is a statement normally everybody try to inculcate. That is, in a primitive society, that means everything is common. From common property, we try to acquire land and we can try to privatize, etc. So that is through the evolution of whatever civilization or human need, private property emerged. This is actually one of the first fundamental understanding normally people may be thinking of. So driving force is scarcity. What is somebody if asked what is actually the driving force of such a transition, which is nothing but scarcity. So this is what is an economic logic normally inculcated. Okay, so the balance between common and private property determined by cost of exclusion, which is proportional to number of firms or people using commons, as well as the size of the commons. So this is what is actually determines the common and private property, right? So land which is equal to real, or tenure which is equal to property, these distinctions are all comes here. So what is the point of property right in land? So this is another set of question normally we ask along with this. Suppose of avoiding a free for all. So why somebody gets land and somebody is not getting land? So this question is a very pertinent one. So reducing the risk and creating incentives, okay, or allowing land to move among users, creating capital. Land is a financial asset, etc. So what is a tenure? A bundle of right. What is a tenure? Which is nothing but a bundle of rights. For example, ownership. In Latin it is called usus fructus abusus. So ownership comes with this thing. You can use it, you can segment it, you can also misuse it or abuse it. So if you destruct the use of the thing as well as you constructive use of the thing. So both sides of the use is being given under the ownership. If I'm owner of something, I can do whatever I like. This is what is actually the kind of meaning with this particular sense, which lead us to a set of another problem, that is tenure and characterized in terms of tenures are characterized. So before coming to that, we have to also clarify that what is a tenure. Okay, so the type of right ownership which is called a freehold, tenancy, which is otherwise known as leasehold, usufruct or use right, concession, license, etc. are called the tenure rights. As well as in the tenure right, you also has who is the tenuree. It is the holder, individual, private, whether it is privately owned, whether it is state owned, whether it is community owned, etc. So in tenures, in tenurial right, you have all these things to be defined. That is the type of right, whether that type of right is a freehold. A freehold is nothing but an ownership which is having almost limited power. Then we had already defined the ownership, the 11 incident, at least you keep that well, point in mind. That is, if we have 11 incident, then we can say that we are a complete owner. So this gives you a freehold. Then you also have tenancy, that is leasehold. All right, leasehold is actually the having a lesser degree of ownership, or what you received from somebody and you are making use as well as produce. Then you have a set of other thing which is called the use of practice or use right. This is also normally very understandable, because if I'm a professor in the university, then I have certain use rights. If you are a student in a batch, then you have certain rights. Okay, so these are called the use rights. Then you have concession, you will be exempted from paying, you exempted from using, etc. So license, etc. So all this is comes under different kinds of tenure. Then also this is related with the same thing which I said earlier, that is whether it is individual or state or community is having all this thing. So tenure are not made in heaven but are created by law. This is very important point which we have to keep in mind. Why? Because in the earlier lecture which we have discussed about it, right? That is, law has to recognize your right, or you can call something as your right if and only if there is a third party acceptance or law accepts it. Therefore, it is very, very important that no tenure whatsoever is being determined by some non-existing entity. So this is very, very important. This is actually gives us a set of other problem, which is we call the example, that is a tenure system includes all the tenure present within a given polity. For example, a nation, or a tenure system consists of tenure several bundle of right and responsibility which complement each other, and institution, land management, administration, etc. Connections to larger system, economic, political, social systems which produce certain results. That results are equity, may be based on equity, efficiency, or more narrowly security, productivity, distribution, marketability, credit access, etc. So this is what is actually a tenure system consists. And the tenure system of most developing country includes several subsystems for different sources also. So this is also very important as far as this particular thing understanding is concerned. And where do we find customary land tenure? Now, normally if we talk about land, then we have to ask this question. So, and what does customary means? And is customary land tenure a necessary one? Now, or to ask it whether this, once it has been emerged, then is it unchanging, or is it community determined or communal, or it is informal or insecure, etc. So all kinds of the sub question has to be asked. So strategies, that is replacement, adoption, etc. has been introduced. That means if you say that there is a customary law that is my forefather is owned this particular piece of land, therefore I have to own this thing, this kind of logic will never exist in the, or never prevails in a changing regime. For example, in the earlier system, you may be having one sort of a land tenure. We have already heard about Raitwari, Mahalwari, then all other land tenure system, tenurial systems. And now in a democratic structure, you may not be having that. So it changes. So it is also based on urgency, land market determined by different aspects like need of people, globalization. That is when you are things become global. Now many people, in India at least, nobody can buy land directly. So the locals buys instead of their Benami buying. So all kinds of this thing exist in across the world. Okay. So reforms that strengthens property right and security is land law reforms. That is normally recently we have a land law reforms, the land tenure reforms, land reformalization, titling and registration reforms, reforms of land management, land administration. These are the things which normally take place periodically. A periodic maybe last very long or it can be shortly changed. So reforms that strengthens access, redistributive land reforms from large private holders to the state, expropriation of market mechanism, tenancy reforms, and other law reforms. Restitution, regulatory interventions, land use planning, land consolidation, etc. comes under this thing. So these are actually the background of what is a economic theory of property right basically deal with. Now, property right in theory, there is a couple of things which, as we move forward, has to be kept in mind. Three important criteria for efficiency of property right. One is universality. This is one first point. All scarce resources owned by someone. Then exclusivity, that is, property rights are exclusive rights, and then transferability to ensure that resources can be allocated from low to high yield users. So these 3 points are being noted and treated as the fundamental principles of economic property right, which was appeared basically in the Demset's 1967 paper toward economic theory of property right, which is in fact a set a neoclassical framework. All three criteria are in place in the long run. So in the long run, or if you have to have a property right, then you have to have a universality, exclusivity, transferability. So in the toward theory of property right, Demset defined that property rights develop to internalize externality when gains from internalization becomes greater than the cost of internalization. So the characteristics of this optimistic view, that is the formulation of decision making with regard to property right, is solely in terms of private benefit and private cost. The theory does not deal with the free riding problem, that play group decision, nor is there any attempt to model the political process. So this is what is actually what Harold Demsetz try to make. And then there are other people also try to conceptualize property right in their own way. For example, if you look into the contract for property right book of Gary Libcap 1989, you will be having a very different view of property as a contract. Then if you look into North's 1990 book institutional change and economic performance, things are not going to be very different. If you look into Barcel's economic analysis of the property right, which is what we are using as a fundamental book, things are different. Egerton, economic behavior and organization, things are different. Then comes Hart's book, that is firm contract and financial structure. There it is actually a different thing. It is actually treat this very concept in a completely different sense, which I have discussed in many early lectures. Like it is discusses in the form of the residual character, which is basically determines the function. So with this, I would end this lecture, and we will discuss all the 5 things in a detail, or in the next lecture we will be discussing about more on these aspects, and we concentrate on it, and we elaborate, we formalize. With this note, let me thank all of you. Thank you very much for listening.